You must object. Protecting your rights when you're sued for debt. Brought to you by Kenneth Chabert at yourlegallagup.com. Your advantage if you're being sued by debt collectors. In my various videos about the rules of evidence and elsewhere, I often say that things are objectionable or won't come into evidence. But this isn't theoretical. It's about action, taking action. This video goes behind those words and tells you one important way you must act in order to preserve your rights. Fail to do this, and they're all out the window, and so is your money. Remember, our system, our legal system, is an adversary system. We have an adversary court system. What does that mean? It means that the legal system pits people and companies against each other and lets them fight it out. And the last man or woman standing is the winner. Sounds harsh? Well, it can be, no doubt about that. But it is based on the theory that good laws and just cases will generally prevail over time. Since we're not God and can't know in advance who's right or wrong, we let litigants fight it out. I wish I could make it sexy or sweet for you, but it really isn't. So for now, just get over it. Our law here in the U.S. is about winning and losing, and justice, if it is to occur at all, is a byproduct. Our job here at Your Legal Leg Up is to try to make sure that you win. Having an adversary system means a lot of things, especially in the debt law case. It does present some real opportunities, as I've often said. Remember that the company suing you is profit-driven, and that means they're after your money, and that's all. Make it unprofitable for them to chase you, and you will likely win, regardless of justice. Make it profitable for them to chase you, and you will likely pay, also regardless of justice. Having an adversary system also means that you must look after your own rights. Only rarely, and certainly not often enough to consider, will the judge or anybody else in the legal system take care of you. If you have a legal right to do something, you must do it or it won't get done. And if you have a right to stop something from happening, you must assert that right in a timely way, or it will happen anyway. You must object. Don't worry how it looks. Just assert your rights. So as I discuss your right not to have evidence count against you, or to require debt collectors to verify your debts, or to prevent them from harassing you in certain ways, remember that you are the one person who can make that happen. In the context of evidence, if the other side is attempting to put information into evidence that violates the rules in any way, you must object to it, or it will go in anyway. And I'm harping on evidence, as I often do, because that's where debt collectors usually don't have what it takes. So for pro se debt defendants, how do you object? Well, that's easy. In trial, you just say, objection, and then you state what you believe is the legal reason the information is not allowed. For example, if the other side wants to give some evidence to the court or jury to consider, that's called introducing it, let's say billing records from your credit card company, you say, objection, hearsay, and then take it from there. I should note that you try to get your objection in before the question gets answered, because, as they say in the law, a bell once rung can't be unrung. If a jury hears something, they can't unhear it. So you try to get your objection in before the answer to the question. So how do you know the question calls for hearsay? That means that the answer is going to be based on hearsay. You have to pay careful attention to what the witness knows and the way the question is framed. If the witness answers anyway, or if you don't get your objection out in time, you move to strike the testimony. Many of these battles can be engaged in and won before trial, and it does help to know how to do that. The litigation manual and other materials here and at my website, yourlegallagup.com, are designed to help show you the ropes. But the main thing to remember now is that if it's going to get done, you're the one who's going to have to do it. And you can. You may not consider this video or anything I say in this or any video as legal advice. I can't give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forms. If you appreciate this video, please take a second and like it on YouTube, subscribe and friend me on YouTube, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.